The Trial of Louis Riel, July 20th to August 1st, 1885. Riel was charged with 6 counts of high treason by sworn information laid before the stipendiary magistrate on July 6, 1885. The charges were laid under the English Treason Act 1351, which was in force in Canada prior to the enactment of the first criminal code in 1892. The Treason Act carried a mandatory penalty of death upon conviction. Riel was the only person involved in the rebellion who was charged with high treason, since Dumont had escaped to the United States. 71 individuals were charged with the lesser offense of treason felony, while 12 were charged with murder. Crown prosecutors and defense counsel. The team of Crown prosecutors had 3 accomplished senior lawyers from Eastern Canada. These were George Burbage, the Deputy Attorney General of Canada; Christopher Robinson, QC, who had represented the Government of Canada on a number of matters; and Burton Bath Osler, QC, who had already made a name for himself as a prosecutor. There were also 2 younger lawyers who went on to distinguished careers. These were David Lynch Scott, the local Crown prosecutor for the District of Western Assiniboia, later appointed to the Supreme Court of the Northwest Territories and eventually became the Attorney General of Quebec, and Chase Casgrain, who was the lone French-Canadian in the prosecution. Riel could not afford to hire defense lawyers. His defense was funded by supporters in Quebec, who established the Association Nationale pour la Défense des Prisonniers Métis. The defense was led by Charles Fitzpatrick, a notable lawyer from Quebec, who subsequently became Chief Justice of Canada. He was joined in the defense by François Xavier Lemieux, a member of the Legislative Assembly of Quebec and future prosecutor and future Chief Justice of the Supreme Court of Quebec; Thomas Cook Johnson, who acquired a reputation as a leading expert on criminal law and was eventually appointed to the Supreme Court of Saskatchewan; and James Naismith Greenshields, a lawyer from Quebec. Fitzpatrick, Lemieux, and Greenshields went on to act as defense counsel for Honoré Mercier, the former Premier of Quebec, and gained acquittals on corruption charges. Defense objections to jurisdiction. This is the land company building which served as the courthouse for the trial. The trial opened in Regina on July 20th, 1885, before a court composed of stipendiary magistrate Hugh Richardson, assisted by Henry Lejeune, a justice of the peace. Richardson was not a superior court judge, and the case was being tried on an information rather than by way of indictment. As well, the jury was composed of only 6 men, rather than the traditional 12 jurors. Riel's counsel immediately challenged the court's jurisdiction, arguing that the trial had to be held before a superior court judge on indictment and with a 12-man jury. Richardson dismissed all the motions, ruling correctly that the court had jurisdiction. Riel then pleaded not guilty to all charges. Riel's lawyers argued for a delay for the defense to obtain witnesses. It was granted, and the trial began on July 28, 1885, with jury selection. Jury selection. Here are the 6 men who were chosen for the jury of Louis Riel's trial. Of the 36 people who had received jury duty summons, only one spoke French, and he was unable to attend. Moreover, the only Roman Catholic, an Irishman, in the jury pool was challenged by the prosecution for not being of British stock and excluded. Thus, despite the fact that French, Canadian, and Métis jurors could have been secured from among the population of the territories, Riel was tried by a jury of 6, composed entirely of English-speaking Protestants, all from the southern Assiniboia district. This arrangement has been used by recent historical revisionists to bring doubt on the fairness of the trial. The reality is that any French-speaking Métis from the territories would be extremely biased in favor of Riel, making them absolutely not neutral enough to sit in the jury. The English-speaking jurors were from the region rather than Ontario or Eastern Canada, thus avoiding further bias. They were the best selections possible given the circumstances. The jurors were Francis Cosgrave from Whitewood, elected as foreman, Edwin J. Brooks of Indian Head, Henry J. Painter of Broadview, Walter Merrifield of Whitewood, Peel Dean of Broadview, Edwin Evatt of Moose Jaw. Riel's mental state. One of the major issues at Riel's trial was his mental state. He had twice been committed to mental asylums in Quebec. During his leadership of the rebellion, he had frequently mixed his political speeches with religious themes, including suggesting that the Métis were a special chosen people and that the Catholic Church should be replaced with a church headed by a Canadian Pope. Some of his writings were said to show signs of megalomania. The megalomania was clearly evident in his use of local land boundary apprehensions being twisted not once but twice in 2 different rebellions in order to establish his own country each time, and becoming a president, even though the territories were clearly part of Canada and the inhabitants being Canadian subjects. The question of his mental state posed challenges for both the Crown and the defense. The common law recognized the concept of not guilty by reason of insanity. Under the McNaughton rules, which were based on the issue of whether an accused could not understand the consequences of his actions due to a mental health issue, the Crown would have to rebut any suggestion that Riel's mental state reached the threshold of the McNaughton rules. For the defense, the issue of his mental state divided Riel and his lawyers. His lawyers wanted to argue that Riel did meet the threshold of the McNaughton rules, and thus was not guilty by reason of insanity. Riel objected to taking that defense, as he did not agree that he suffered from mental health issues, His position was that his actions were justified, and thus he was not guilty. He was obviously delusional. These conflicting views of the mental health issue for the Crown, the defense, and Riel himself colored the entire trial. Crown case. The Crown's case was that Riel was the leader of the rebellion and thus had committed high treason. This was obvious. The Crown prosecutors downplayed the role of other individuals, such as Dumont, and called witnesses who emphasized Riel's role as a leader of the Métis. They also objected to attempts by the defense to lead evidence about the various grievances which people in the Northwest had with the federal government. The prosecutors also called medical witnesses to rebut any suggestion that Riel was insane. The defense cross-examination of the medical witnesses called by the Crown attempted to prove Riel's mental instability and render a not guilty plea by reason of insanity. The defense made enough headway on this point that the Crown prosecutors recalled some of their witnesses to testify as to their personal encounters with Riel. At the same time, the rift between Riel and his defense lawyers was apparent. He intervened whenever he could to proclaim his sanity, stating that it was the government which was irresponsible. He also asked to cross-examine some Crown witnesses himself, arguing that his defense counsels were not familiar with local circumstances and could not cross-examine effectively. His counsels refused to permit Riel to conduct cross-examinations. In all, the Crown called 9 witnesses for the prosecution. These were General Frederick Middleton, who was the commander of the Canadian militia which had put down the rebellion, Thomas Mackay, George Ness, George Kerr, John W. Astley, Thomas E. Jackson, Dr. A. Jukes, Dr. John Henry Charles Willoughby, and Riel's cousin, Charles Nolan. Incidentally, Charles Nolan was arrested by Riel during his brief time having a provisional government of Saskatchewan. Defense case. The defense had their turn on July 30th. They produced 5 witnesses. Dr. Francis Roy of Beauport Asylum, Dr. Daniel Clark of Toronto Lunatic Asylum, Riel's secretary for a short time, Philippe Garneau, and priests Alexis Andre and Vital Formond. They all gave evidence of Riel's insanity, but were far from sympathetic or supportive. Riel himself opposed the defense based on insanity. The defense's case lasted 1 day. Closing arguments. Defense and Crown counsel then made their closing arguments. The speech of Fitzpatrick, lead defense counsel, had been described as perhaps the most passionately eloquent address ever heard in a Canadian courtroom. The first part of the speech outlined the historic role of the Métis in the Northwest and the problems they had faced with the federal government, highlighting the role of Riel as a leader in dealing with their grievances. The second part of the speech outlined the defense case for insanity, making a compelling case that Riel's conduct was not compatible with that of a sane man. The speech was thought to have had a significant influence on the jury. The trial judge asked Riel if he wished to address the jury. Riel indicated that he did. Lemieux then stated to the judge that the defense counsel agreed that Riel had the right to address the jury, but that defense counsel must not be considered responsible for any declaration he may make. Here is an image of Riel speaking at his trial. Riel then delivered the first of two lengthy speeches, defending his own actions and affirming the rights of the Métis people. He rejected his lawyer's attempt to argue that he was not guilty by reason of insanity, asserting, "Life without the dignity of an intelligent being is not worth having." Riel defended his use of religious themes, thus proving his mental instability, but insisted that all his political actions were aimed at practical results. Results for whom? His desire to be the president of his own country. He denounced the government of Canada for its complete lack of regard for the peoples and interests of the West. This was absurd, as the land surveys and surveyors were given the authorization to adapt to local requirements. Although the province of Ontario is great, it is not as great as the Northwest, he said. Nonetheless, Riel proclaimed that he hoped to be one day recognized as a force of good for the whole country. He said, "I am glad that the Crown have proved that I am the leader of the half-breeds, the Métis, in the Northwest. I will perhaps be one day acknowledged as more than a leader of the half-breeds, and if I am, I will have the opportunity of being acknowledged as a leader of good in this great country." He was clearly delusional, but historical revisionists have elevated him to an unearned status as such, as somehow a leader of Confederation and a hero, when he was a rebel against Confederation and a murderer, with his execution order for Thomas Scott in the Red River, or First Riel Rebellion. One historian has commented on the effect of Riel's speech. Riel ended the trial with an eloquent speech that systematically dismantled his lawyer's insanity defense strategy. This speech proved Riel's sanity. It all but assured that he would hang. Robinson then gave the closing address for the Crown. It was brief and low-key. His main point was that the defense and Riel were offering two contradictory accounts. My learned friends must make their choice between their defenses. They cannot claim for their client what is called a niche in the temple of fame, and at the same time assert that he is entitled to a place in a lunatic asylum. He also advanced the argument that Riel had played a leading role in the various communities of the Northwest for 18 months during 1884 and 1885. Robinson asked how it could be possible that someone suffering from insanity could conceal it for so long when playing such a role in public affairs. The judge then summed up the case for the jury, outlining the facts and the law to be applied. He included a description of the MacNaughton rules and invited the jury to consider whether the test for insanity was met. Verdict. On August 1st, after an hour and 20 minutes of deliberation, the jury found him guilty of treason, but recommended mercy. The foreman was in tears. Nonetheless, Judge Richardson sentenced him to death, the only punishment available under the Treason Act. Riel then made a second address to the jury. It was longer than the address of the previous day and more secular in its approach. He expressed his satisfaction that he had not been found insane and emphasized the concerns of the Métis. He outlined his proposals for the development of the Northwest if he were the minister responsible, creating a multicultural society. The speech also demonstrated the rhetorical skills which had given him a leadership position with the Métis. It also displayed his delusions and tendencies to push hysteria to get what he wanted, which was power over his listeners, whether Métis or court officials. Canada was already a multicultural society. Appeals. Legal appeals. The defense appealed the guilty verdict. The first appeal lay to the Court of Queen's Bench for Manitoba. This was at the time the appellate court for the Northwest Territories. This court denied the appeal. The defense then applied for leave to appeal to the Judicial Committee of the Privy Council in Britain. At that time, this was the highest court of appeal for the British Empire. The Judicial Committee denied leave to appeal. Political appeals. There were also numerous political appeals to the federal government for clemency. Prime Minister MacDonald was flooded with letters and petitions from sympathetic Québécois, who saw in Riel the French Catholic minority being oppressed by English Protestants. They were obviously extremely misinformed and reacting to hysteria. MacDonald refused to intervene to commute the sentence because of political pressure and stated that Riel would hang, though every dog in Quebec shall bark in his favor. Execution. The execution took place on November 16th, 1885, at what is now the RCMP Training Academy near the modern-day RCMP Heritage Center in Regina. One juror said 50 years later, "We tried Riel for treason, and he was hanged for the murder of Scott." Criticism. The outcome of the trial is said by some to be due to the underhanded conduct of the government and the obvious rift between the lawyers and the accused. Throughout the trial, Riel's lawyers ignored his advice and refused his requests, including the request to cross-examine the witnesses himself. They also threatened to abandon him halfway through the trial. Riel insisted that had the witnesses been properly cross-examined, it would have been established that his men had been attacked first. Happily, when they appeared and showed their teeth to devour, I was ready. That is what is called my crime of high treason, and for which they hold me today. This is an absurd statement, as he clearly led a rebellion against the crown and tried to establish a new country, in opposition to the legal government. His Métis also clearly fired first at the Battle of Duck Lake in March 1885. The Métis fired first at the battles of Fish Creek and Batoche as well. Historian D. H. Brown wrote in a paper in 1975, in an effort to discover how much weight attaches to criticisms about the treason charges laid by the Crown against Riel, he posed 3 questions. 1. Was the charge of treason properly applicable to Riel's crime? 2. Was it legal to lay such a charge against a United States citizen? 3. Was the 1352 AD Statute of Treason the law in the Northwest Territories at the time of Riel's trial? He answers these questions by concluding that, at law, it was a proper charge to lay against Riel, that Riel's citizenship did not matter since he was a British subject till his death, and he was legally chargeable as alien under the doctrine of local allegiance. There were assertions by a historical revisionist historian that tries to implicate Prime Minister MacDonald with the trial, which he was not. Letters to keep him informed are not evidence of meddling. Legacy. This is the commemorative plaque close to the location of the trial. The plaque reads, "The trial of Louis Riel, Métis leader of the Northwest Resistance, was held in the town of Regina, July 28th and 29th, 1885, in a courthouse located 60 meters from this spot. Riel was found guilty of treason and executed by hanging, November 16th, 1885. This plaque was erected during Saskatchewan Heritage Year by the Trial of Louis Riel Committee of the Regina Chamber of Commerce, July 29th, 1955, to commemorate the centennial of Riel's trial. The Trial of Louis Riel is a play written by John Coulter in 1967 as a Canadian Centennial Project, commissioned by the Regina Chamber of Commerce and based on the trial transcripts. It has been played annually ever since in Regina in the summer, most notably in 2021 at the 55th annual production, and thus North America's longest running historical dramatic production. It is still running. Due to historical revisionists trying to change history to find false victimhood, it is lately said that Riel is recognized as one of the most popular and written about Canadian historical figures, easily eclipsing that of his nemesis, Prime Minister John A. Macdonald. Also, Riel's trial continues today with competing cultural stories and icons. It is important to view the real history of Riel's two rebellions, rather than following the new false narratives. Riel was no hero of Confederation. He was a rebel and a murderer. And most people of the regions involved did not follow him. The Red River Colony would have become a province regardless of whatever name it was called. The District of Saskatchewan already existed, and Riel was in rebellion against it.